Good morning, and good morning again. Uh, we're presenting today from Antioch Baptist Church, and this morning the program is entitled Have Your Say All the Way. This is maybe the third time that we've had this workshop, and we've had good response from that. And so I'm looking forward to today's program and the information that'll be exchanged. For those of you that are watching us digitally, we do have forms that you can pick up at the church, and if you choose to prepare them at a later date. So thank you once again for joining us today. I'd like to begin by asking Minister McKinney to open the workshop with a prayer.
Thank you, Deacon Locke. Shall we pray? Now thank we all our God for this day, for your amazing love. Thank you, Jesus, for being our Lord and Savior and our risen King, provider of every good and perfect gift, all that any of us will ever need for all the issues of life. Have your say, Lord, all the way, in all of our lives, in the works of our hands, serving your people for this and every bereavement ministry, workshop, and endeavor, so that we may support families and inspire hope. Death couldn't hold you down, and fear of death and all related things cannot make us fear or lose hope. Thank you, Holy Spirit, for your wisdom, knowledge, and understanding that birthed this event. We are grateful to serve and grateful for those who are serving and standing in the gap. Preparing for the end of life matters is right and proper for God's redeemed people, and as an example for those who may not know you, Lord, yet but surely may be drawn to you, serving your saving grace and eternal life by our obedience to offer this service. Hallelujah. In 2 Corinthians 1 and 3, we praise you, blessed God and Father of our Lord Jesus Christ, and Father of mercies. Thank you for being the God of all comfort. You comfort us in all afflictions. You do that, Lord, so that we may be able to comfort those who are in any way afflicted with the comfort with which we ourselves have been comforted. This is what you charge us to do, and this is what our ministry strives to do. Thank you, precious Savior, for being so patient to hear our prayers, console us, and make us to be those who share hope with another and like-minded in being loving and kind and filled with faith, joyful hope, peace, believing that it is your will that we shine as lights in the world through the power of the Holy Spirit. Amen.
Thank you very much, Minister McKinney. We also want to take this moment to introduce our presenters today. And as we begin this journey in education, to have your say all the way. First off is Ms. Kennedy. Ms. Joy Kennedy has been practicing law since 2005 in child custody matters, juvenile criminal defense, domestic relations, estate planning, probate administration. She's licensed in the state of Ohio and the United States District Court, Northern District of Ohio. Ms. Kennedy received her bachelor's degree from Hampton University, a master's degree in social work from Virginia Commonwealth University, and her Juris Doctorate from Cleveland Marshall College of Law at Cleveland State University. Accompanying Ms. Kennedy is Kalila A. Lawson. Kalila currently works as a magistrate for the Cleveland Municipal Court and also volunteers as a magistrate for the East Cleveland Juvenile Diversion Program. Kalela was also a magistrate for the Cuyahoga County Probate Court. She's served as a Cuyahoga County prosecutor and is also a former defense attorney. Kalela is a native of Cleveland, Ohio. She graduated from Collinwood High School and obtained a degree in English and criminal justice from Grambling State University. She received her law degree from Western Michigan University with a concentration in litigation. Kalela is a member of Alpha Kappa Alpha Sorority Incorporated and an avid supporter of historically black colleges and universities. She serves as a board member on the Cleveland Metropolitan Bar Association and volunteers with a host of other community organizations. Her goal is to be an inspiration to students who may not have a roadmap to success and be the guide that helps them reach their full potential. In addition, also present with us today is our representatives from the E.F. Boyd and Son Funeral Home. Marcella is the youngest daughter of late William F. Sr. and Mary W. Boyd, and the mother of two. Marcella graduated from Lutheran High School East and was inducted into the Hall of Fame. She attended Baldwin Wallace College and Cleveland State University. Marcella became a licensed funeral director in 1988 and was appointed in September 2017 by Governor John Kasich to the State Board of Embalmers and Funeral Directors, where she served until March 2019. She is a member of the Cleveland chapter of Girlfriends, past president of the Greater Cleveland chapter, Top Ladies of Distinction Incorporated, National Coalition of 100 Black Women, GCC, 100 Black Women of Funeral Service, Buckeye State Funeral Directors, Legacy Life member, National Council of Negro Women, Cuyahoga County Section, Cleveland Cleveland MOTTEP Board member, and the Cleveland Drifters. She loves serving the community and families. Thank you very much. I will now turn over the mic to Joy Kennedy.
Good morning, everyone. Good morning. I am happy to be here, happy to speak with you, and glad that we are now able to return to an in-person setting. For so many years, or for many years, we presented this program here at Antioch in a need to share this important information with all of you. This program's inception began with the late, great Gladys Dunbar. She believed that people should have their say all the way. And so we started giving this presentation to educate the members of Antioch on the forms that are necessary and can be very helpful as we plan for the future of ourselves and our loved ones. So the documents that we have gone over in the past include your will, your living will, your power of attorney, and your healthcare power of attorney. I started off with the presentation, and I always called it getting your house in order. If you get your house in order, it will be in order when that time comes. When you are going through your grieving process or your loved ones are grieving for you, you want them to deal with that particular issue, not all of the other issues that arise outside of that situation. And so I got my start, or I began with my grandmother. I was her favorite grandchild. She loved me more than any of her other granddaughters. I was her only granddaughter. So I guess that kind of helps. Um, but but we had a wonderful relationship. And she instilled in me many of the values that I have, the family, the work, all the ethics that I can think of. And so she tried to make sure that she had the proper clothing to change into because I was the girl. I was the one who needed to make sure that Granny was okay. One day I went there and I found a card, a postcard that had come to the center. And it said that you need to decide or identify your beneficiaries for your life insurance policy. So apparently, she had her husband, my grandfather, but he predeceased her. So now you need to identify new individuals um, on your form. But at this point, Granny had already transitioned beyond the point of making those decisions. So I said, okay, I'm the lady. I am the surrogate of Granny. So I called. I'm like, hello, I'd like to identify a beneficiary. And they said, no, you can't. You can't do that. It has to be her. And I said, well, she can't. And they said, well, you need to go to the probate court and get the authority to do so. I was young, didn't really know what to do, was still in law school, so didn't really understand the laws as it related to that. She had a power of attorney form that was completed, and her son was listed as that person to handle those things, but he didn't. So I knew she had life insurance, but I had no idea of what it would be. So Granny continued to decline, and we never knew how much she had in terms of life insurance. Um, I didn't have her social security number. I didn't have any of those identifiers. My father didn't know where those things were. We didn't have access to that information. So we just continued not kind of living blindly. She then transitions and declines even more and is placed in hospice. So when we're at hospice, I'm there with her and my brother is there. And she ultimately passes away. When she passes away, we still don't have any information. But the hospice nurse leaves her file in the room. I look at it. I see her social security number. So we're finally able to get the information. But at this point, she's already expired. We find out that she has insurance, but it's only $2,000. You know what it costs to bury people, several thousands, not 2,000. We're talking 8, 9, 10,000 or more, depending on what you choose. So at this point, we realize we do not have enough money to bury her. So I reach out to a funeral home and they take her body. And then my dad and I go and meet with the funeral home. And although they did not use these exact words, they said, we have a cooler in the back and we will keep her here until you have the money to bury her. And I was clear, those were not the exact words, but the words that they shared with us said, we have her body and we will keep her here until you have the money to do whatever it is that you want to do with her. My grandmother had purchased a plot at Lakeview Cemetery next to her husband. We didn't have the money to open and close the vault. Didn't even know about that until we get to this point. She paid for this plot, but you can't pay, or you couldn't pay at that time, to open and close the vault until the actual time. So we are now in the hands of someone else. We don't have the money to do the things that we needed to do. We didn't have the power of attorney forms. We didn't have the living will. We didn't have the forms that we're going to talk about today because we were not prepared. Although she made many attempts to get her house in order, those things weren't shared with the family. So when you do these things, you have to share them with your family, include them, have them in a place or a space that they're accessible, because otherwise it falls upon deaf ears. So we were able to get the money, but that funeral home said, if you do the bare bones, you can have X and Y and Z. And we can send her to this cemetery because that's the one we contract with. We don't contract with that one. And if you have the money to pay to open and close the vault, which is about $1,000, then you have the money to pay for a different service. So you decide what it is that you want to do. So we ended up going with the bare bones service. And so she is now buried in Riverside versus Lakeview because we didn't have the money. So this is not all about money, but it's about preparing your family so that when that time comes, whether it's for you or your loved one, you are prepared in a way that will be feasible and appropriate for what it is that you want. So when we did our seminar, we talk about your will. We talk about your living will. We talk about your healthcare power of attorney, and we talk about your power of attorney and the importance for each one of these forms and how your life or your family's life can be impacted without them.
Good morning, everyone. And just to echo a lot of the sentiments that Joy just spoke about, I've had these same conversations within my family because of situations that happen like that are very, very unfortunate, and things I've saw as a magistrate and just working in probate court. I've had to have sit downs with my family, and I say, okay, everyone, we need to have a family meeting. You know how we do. We need to come together maybe on a Sunday afternoon after church. We have some food, but we need to have these conversations because the talk of death can be very taboo, especially within our community, and we just kind of stray away from it. We don't want to talk about it. We don't want to address it until it's time to address it. So what we do, and what I also suggest you do within your families, is have a conversation. Find out, mom and dad, where is the will? Is it in a safe? Is it in a cabinet? Do you have it on file downtown? Go get the will. Can we look at it and talk about it together? So I know what I'm looking at. I know what your expectations are. And God forbid if someone tries to come and present another document that is not what we went over, I know that, no, that's not mom and dad's wishes or cousin or uncle or whomever. We talked about the will. And so you see the documents ahead of time. Everyone feels a level of comfort and that ease that we've discussed it. We talked about it. We're on the same page. Get the bank account numbers. Again, there's always sometimes these issues of trust and money, and you just want to know my business. I had to have a conversation with my grandmother before she passed and say, Grandma, it's not about someone wanting to know how much money's in your account or what you have. We want to make sure when it's time, I know where your assets are. I know what bank to go to report it on the forms and documentation. and I can report, okay, there's a PNC account, there's a Huntington, there's a Chase. I know where your 401k is, where your IRA is, who the beneficiaries are. I asked my parents. We sat down at the table with my brother. Who's on the accounts? Who's the beneficiaries? It's no secrets. We don't have time for secrets. It is what it is. If I'm designated, if he's designated, let us know, because in that time of grief, a lot of other emotions come into that. Anger, bitterness, whatever the case may be. And then it gets to be other issues that aren't necessary. But if we talk about it ahead of time, we know social security numbers. We made copies of those for everyone in the family, within our immediate family. We designated a specific folder where everybody knows where it is, down to key codes and passcodes to get into the house in your alarm system, because that is a big issue where I've seen, well, we can't get into the house. We don't know the password to get into the house. And then you don't have authority to go to the bank or the mortgage company or the rental property. They're not going to allow you in the house unless you have documentation that says, I'm supposed to go in here, but we need to handle our loved ones' property, take care of things in the house. We can't get in because we don't have the key. So back to getting your papers in order. Those things that we're thinking about now that you don't have the capacity to think about in the time of death. Get the account information so we know assets, copies of social security cards, copies of beneficiary information, life insurance policies, because as our loved ones decline in age, they may not always remember. So let's talk about it now and say, well, who's your pension through? Do I need to contact Medical Mutual? Who should I be talking to? The phone numbers, who's the agent, the insurance agent. So all those things are very, very important. And I'm so glad that we're here and happy to talk about it, because again, we need to get our house in order, our papers in order, so that we can thrive in life, so we don't have to deal with certain grief in that time of death.
So I'll briefly talk about the will and the living will and the difference between the two.
We have forms for living will, habit, trinity, kind of go through it together.
So we have your will. A will is a document that is used to devise or to distribute any property that you have after you pass away. The will comes into play when you pass away. After you pass away, that is when your will comes into play. The living will, however, is a lot different. People say that I want to create a living will. I want to create a living will. A living will is extremely different from a will. A living will is a document that is used to determine your wish as it relates to life-sustaining treatment, including artificially or technologically supplied nutrition and hydration, and whether or not it will be withheld or withdrawn if you are in a terminally ill or permanently unconscious state. So many people skip over the living will. Oh, I don't need that. I don't need that. I just want to do the will when I explain it to people. But the reason why that living will is so important is because without this document, you are putting the decision into the hands of someone else. Now, as a daughter, I don't want to make that decision for my mother or my father. Mom, Dad, you make that decision. Don't put that on your loved ones, because that then breeds fighting amongst your siblings, your children, or whoever is responsible for making that decision, especially if you leave it to the oldest one and the youngest one believes that they should make that decision. Or the middle child, the one who always causes ruckus, the one who is all that one. And then now they're fighting afterwards, and they're not speaking anymore because you're not there to tell them to talk to one another.
Even in that time is very precious that you have to make the decision. So you're under pressure not only to make that decision, but make sure you're making the right decision. And amongst bickering and arguing and feelings and emotions, doctors are coming in and saying, hey, this is our timeline. If we don't make this decision, A, B, C, and D can happen. So again, just to be able to make that decision where we're not wasting time, we can do what's in the best interest of our loved one.
And so to bring it very close to home, my uncle, 58 years old, he'll be 58 in a few weeks. Super Bowl weekend, he was over and they're watching the game. And as he's talking, his voice is going out. And we're like, what is wrong with you? Why are you talking like that? But he has not been to a hospital probably in as long as I've known him, as long as he's been living. Maybe he's been. But he's a heavy drinker, heavy smoker, and was enjoying the Super Bowl, and his voice was going in and out. Well, last night I learned that he has stage 4 cancer. He has cancer of the larynx, of the throat, of anything that you can see in this region. So they need to do emergency surgery. They did it a few days ago. They put in a temporary trach. So he's able to talk right now. Right now he can talk. But on the 27th, they're going in and they're taking it all out. Everything in there is coming out, and they must do reconstructive surgery, and he will have a permanent trach, and he won't have a voice box, right? 58 years old, he has no children, no spouse. He just has his siblings. So now his siblings will have to make a decision for him if he doesn't prepare this particular document right now. Right now. He could have prepared this document 5 years ago when there was no sign, no thought of this. He still can do it. But if you don't do these documents ahead of time, then you have other people fighting over what should be done. And it may be the one that you don't want to fight, because he's saying, I don't want my sister up here. She gets on my nerves. He's saying that, but he doesn't have the documents in place. And if she gets there before the brother gets there, who gets to have their say? You want him to have that say. And that's what this living will document is for. And you have a living will document before you. It's called Ohio Living Will Declaration. If you want to complete this form with us today, we can go through briefly what this form asks of you. And then at the conclusion, we can have you sign the form and have the form notarized, because this will give you your say. So on page 2 of this document, that is where you simply put your name and your date of birth. You will find right below that exactly what this living will declaration is. It's saying that this is my only living will. Any other documents that I have ever signed relating to a living will be trumped by this one. Now, I will pause and say that anytime you go to the hospital, usually at the end, when you're meeting with that person who is inputting your information, they'll ask you, do you have a living will? Do you have a healthcare power of attorney? And they will either check yes or no. And then they'll move on to the next question. They don't want to hear, well, I was thinking about it. They don't want to hear, well, my mom and them had one, but I didn't finish it. They will simply ask the question, and that answer becomes a part of your medical file.
And just chiming in to say this, sometimes it goes over our heads because we're in front of medical professionals. They ask these questions. It's just yes, no, yes, no, yes, no. And then sometimes we don't realize until after we leave the hospital or whoever was questioning us, oh, wait, they did ask about this. Maybe I do have it or I'm not sure. So they're just doing their job. You know, they're not there to kind of hold your hand and say, well, are you sure the form looks like this? No, they're asking yes, no, yes, no. So with doing these forms, we want to make sure that they have them because they're going to be able to make that phone call a lot of times.
Exactly. And this form, once you complete it, you can make a copy of it and put it in your file of record. You give this to your doctor, your healthcare provider, and it is available anytime you go. And the next time you go and they say, "Do you have a living will?" "Yes, I do."
And it should be a part of their medical record.
It's a part of their record. They may still ask.
Mhm.
You can say yes. And so when you're in the hospital, when you're in a nursing home, when you're in any type of healthcare facility, this document follows you. We know everything is electronic now. It may be My Chart. It may be Health, Follow My Health if you're with the university hospital system. Either way, this document is available. This document contains very simple information. You determine whether or not you want to have those life-sustaining treatments to continue or if you want them to stop. This document has several definitions in it. So once you go past page 1 or page 2, which includes your name, you'll see definition. This is what it means to be an adult. Anyone over the age of 18. An agent. Who are you assigning as your agent? The agent is the person who you want your doctors to reach out to. Who do you want them to call?
And make sure that your agent has a copy of this form as well.
Absolutely, because if they don't have a copy of the form, then they don't know that they will be charged with the responsibility to be that person or that contact person.
Because I've seen in situations where people are elected as agents, but the agent does not know and they're not even aware, and the conversations are not had, and they get the phone call and say, "Well, I had no idea that they appointed me to be the person." So you can't just write somebody's name down. I mean, technically you can, but have the communication with the person so that they know.
And then also communicate with that person what your wishes are. Don't just do the form, but tell them, this is what I want. And it is not an easy conversation for you to even have with someone to say what you want, because it is still difficult for many people to grasp end of life situations. So, do you feel comfortable going to your son and daughter saying, if I am in a permanently unconscious state or a terminal situation, this is what I want to happen? Because sometimes we don't know. Sometimes I want you to say, pull a plug. I don't want to do this anymore. But when you think about it, sometimes people say, I don't want to be resuscitated, or I do. So when my grandmother was in the nursing home, she began to decline and went from a certain weight to being under 100 pounds. And so my dad is an only child. And in his mind, he wants his mother to live forever. So he wants the doctors to do everything in their power to keep her alive. And I get that from his perspective. Keep my mom alive. So if she says do not resuscitate, but he says resuscitate at all costs, who do they listen to? If you have this form, they're going to listen to you. But if you don't, they're going to listen to your loved one. So this form says, this is what I want. This form trumps what anybody else wants. So in her situation, she didn't have it. So he said, resuscitate at all costs. And I say to him, well, you know her bones are brittle. You know she can't communicate. So if you resuscitate her and you break a bone, now she has to live that way? Is that what you want? So now she has to live in pain? So we don't often think about it from the person's perspective. We think of it from our own perspective. And for him, he wanted his mom to live forever. She also was being tube-fed. And he wanted her to be tube-fed. He wanted her to have the nutrition. He wanted her to be healthy, but it got to a point where her body began to reject the tube feeding. So he says, well, we need to take her somewhere else then.
Mm-mm.
Daddy. But that's his perspective. That's a son's love for his mother and his desire to have her live on forever. Is this what she wanted? Did she want the pain? Some people, especially when they're dealing with certain terminal illnesses, become tired, and they can tell you that.
Mm-hmm.
But sometimes they advance very quickly or to a point that they're not able to communicate with you. But this written document allows you to do that. So if you look at page 3, you'll see more definitions, the life sustaining treatment and what that means, the artificial feeding, the hydration that is provided, and whether or not you want that. It also determines what a permanently unconscious state is.
And I think those definitions are key because a lot of times in our mind, we try to determine what that means. And what we think something means is not always the legal definition or the medical definition that those healthcare professionals are going to abide by.
And permanently unconscious is determined by a medical professional,
Not us.
not by me. Um, the doctor must render an individual to be in a permanently unconscious state. When the doctor renders that, that becomes a part of your medical file, and then it is the living will that they look to see what is it that you want to happen from there.
Yep, it's like a triggering condition.
Mhm. A living will has no expiration date. So you may be in a particular situation. We are on page 4. Sorry about that.
See, we can read the room. We understand what's going on. We want to make sure everyone's following along.
And it lasts as long as that document is a part of your file. When you read through the definitions and you get to page 4, it indicates the first contact name and relationship of the person that you want to identify as the contact person for the doctors. Then you ask yourself, who do I want to be that person? My son, my daughter, my neighbor. It does not have to be a relative. It can be anybody that you find to be the closest person to you. So that is the person that the doctor will call. And we name our son, but your son doesn't have a phone. How are they going to reach him? Your son doesn't pick up unknown callers.
They don't check voicemails. It's only a text message. The doctor is not going to text you. So that's why we say make sure that they know, that they're aware, because our generation is different. We know that generations have changed over time, and the doctor's not going to Instagram, Snapchat, DM you. So make sure when we're designating these people, we want responsible adults. We want junior, the third, whoever to know you are on this form. If something happens and you get a phone call and it may say Metro Health, it may say UH, answer the phone.
Mhm. It gives you the opportunity to identify 3 people. If they can't reach first person, who's the next person? You may have that son on there or that daughter who doesn't answer very often, but don't have them as the main contact. Don't have them as the first person to reach out to. And this is simply the living will. This is to determine who to contact, to tell them that you have been rendered permanently unconscious or in a particular state, which triggers what happens as a part of your living will.
Keep going.
Yeah.
Yep, keep going. Keep going.
Okay. So this is, we were trying to make sure we brought it up on the screen.
That's
And
our
so-
healthcare power of attorney.
This is the living will, and we are on page 4 of 7. Is there anyone who wants to work on this form and have it signed and notarized before we leave today?
Yep. Yep, that's the form.
The living will, as I explained, is the document that determines your wishes while you are still living. It differs from a will because the will determines what happens to your property or your assets upon your death.
And I'll just say this in regards to dealing with wills versus living wills. Some of our family members may not be comfortable with doing a will. I've had conversations with family. Well, I don't have anything. I don't have any money. I don't have bank accounts. I don't have this. Okay, well, you know what? That's fine. We're not going to argue about it. You don't want to do it. That's your business. But at least if you have a living will, we don't have to sit and talk about your assets, going through accounts and 401ks. This is a simple form, literally, that you just fill out so we know if something terminal happens, we can take care of it. So a lot of times, some people may be more comfortable with just filling out a living will and maybe not a will. And sometimes we have to be okay with that and meet people where they are.
Now, we can talk about the will and the importance of it because we hear so many times, I don't have anything. Many times that's not true. It's really not true. If you have a bank account, you have something. If you have children, you have something. And you want to make sure that whatever you have goes to the ones you love.
And even those family heirlooms that we may not attach monetary value, but there's emotional, there's spiritual value to it. And a lot of times those are the items that we end up disagreeing about because we did list those and we say we don't have anything. But then when you transition, there's the furs, the jewelry, the hats, the furniture, the recliner. That was grandma's favorite recliner, and I want that in my house. That is something, and that means something. So we need to outline all of those things in a will.
And again, this is a difficult conversation because I ain't going nowhere. Is the belief that everybody has.
Right.
That's the belief. So we want to determine how do we devise our assets.
And I think another one we hear is, well, they already know who's supposed to get it. I already told them who gonna get it.
Who'd you
Who'd
tell?
you tell?
And do they communicate with one another?
Right.
Because you told your responsible child, but not the irresponsible child, because the irresponsible child wasn't there. They didn't answer the phone. They didn't call back. And so you never got to tell
But
them.
they show up
Mhm, mhm.
at that time, and me and mama, exactly.
And they're the loudest one. So they're going to fight about it at the end of the day. And so we always talk about creating a will. One of the biggest things that we talk about when it comes to the will is property. That is one of the issues that I found to be the most interesting and sad at the same time when you talk about your property and passing it on to our loved ones. We talk about generational wealth and building that, but we drop the ball so many times when it comes to that. Because people come to me about grandma's house, and we look in probate court because we want to transfer grandma's house, but we find out granddad's name is still on the house.
And who predeceased who and who's still alive and who does it go to? Because you may feel like I'm the child, it goes to me and my siblings, but granddad's name is on the house with grandma's name. They own it together.
Mm-hmm.
So it don't go to you.
And granddad died in 84. He
So
was young.
He predeceased grandma.
Grandma, he died in 84, and it's 2023.
23.
You need to open up an estate for granddad. And who would the beneficiary have been?
But let me
Grandma.
let me add another twist though,
Mhm.
because what if granddad had kids that were not with grandma?
Mm-hmm.
So he has a set of children as well. You know, we don't like to talk about things, but we got to open that paperwork.
Mhm.
Those children may be entitled to something.
Exactly. Now, even if he didn't, he died in 84. Grandma died a while ago in my scenario. So now you got to open up a state for her because you're trying to pass the house on to the kids. It becomes so convoluted that many times you will see homes sitting in our communities because we can't do anything with them.
And that's why they're abandoned.
They become abandoned.
Mhm.
They were perfectly good homes or homes that needed TLC, but we couldn't do it because it was too much and the legal fees would soar if we tried to open up granddad's estate and grandma's estate and then pass it on to others.
And you're dealing with, at that point, deeds and titles. And those titles have to properly be transferred in order for you to put a house on the market, in order for it to be to have to sell. You have to have clear, good title. And we can't do that if we're not opening up estates.
And this is not this happens every day. Every day I have seen it. She has seen it working in probate court. And we have to do better in terms of making sure when a loved one passes away, we check the deed. Who's on that deed? Because we say we'll get around to it. And listen, all of these examples come from my family.
I had something from my phone,
Hattie
too.
Bell, she died in the 90s. She had 3 children. Her daughter has lived in the house ever since. And you say, cousin, did you take care of it yet? Oh, I'm gonna do it. I'm gonna do it. The house still is in Auntie's name. So guess what? When it's time to repair the roof,
It's not in your name. You don't have authority to
you
do that.
can't get a loan, or when they need to take out I forgot what it's called, to do that, because in order to do roofing work or real work on the house, you have to get a permit and you have to get the owner of the house to sign off on it. She died when? So then the house still sits with a roof that's rotten because the kids won't transfer the into their name.
And they can't at this point.
They can't unless they go through probate court and open up an estate and do all those things that they're like, nah, we're not going to do all that.
And I'm going to add another layer to this, which things I have seen personally, where the loved one passes away. The daughter, we're going to go with the daughter. She's living in the house, but there's other siblings. And now these siblings come and say, well, we want to sell the house. Well, I'm living here. This is my house. Mom, I've been living in this house with mama the whole time.
And I took care of mama.
I took care of her and I pay the bills. But your name is not on the deed. And we want to sell it.
And now they're fighting. The fighting is what ultimately becomes an issue when you don't have your say. So have your say now. We can put that property in the will. But I was talking with someone this morning, and one of the better options is that transfer upon death affidavit.
You can do that now.
People always say, I ain't got nothing, but you have a house. Well, it ain't worth that much.
Don't matter.
But your loved ones want to be able to do something with it when you pass away.
Whether sell it, give it, donate it, potentially, whatever they want to do, they need to have the authority to do so. And I will say, without a will, when you're dealing with a house, somebody passes away without a will, it's called intestate. And in regards to that property and that home, it has to be divided equally here in the state of Ohio. So you may have siblings in California and Texas, and you're here. And I've had situations where people say, well, I'm here in Ohio. I'll just take care of it. I want to do it. If they did not have a will, it has to be divided equally amongst everyone. Now, that other sibling can always transfer their interest to the person here, but that's another extra step that's not necessary if we just designate in the will where we want the property to go.
Mm-hmm. Mhm.
It's really only between the two of the nieces. The grandson really does not come into the picture.
The two of your nieces, because that's their daughters.
Yeah, their daughter and not the grandson.
Okay.
So exactly, what you're talking about is a situation when someone outside of the line of
The lineal descendants.
tries to step in.
And you're dealing with an out of state issue.
And an out-of-state issue. The first thing that I will say that is when there are out-of-state issues, is very important to have an attorney involved
And an in state attorney.
in the state in which the will is being probated. That's most important. Sometimes people try to go to a different state. So, for example, when someone has property in Illinois, if that will is from Ohio, then that will has to be processed or probated in Ohio. And it can devise the property however it is requested, but it has to go through the court in which that state in which that individual is from.
And if they're a legal resident of Ohio, it can be probated here in Ohio. But what you were saying is that your grandson is coming in and trying to assert his authority, saying that he's a son, and he really does not have that legal designation to do so.
Which is illegal.
Mhm.
Even at the time, my great nephew,
Mhm.
he put my sister-in-law into a nursing facility and said that he was the son. No, that he's not the son. He was coming with individual papers saying that I was the son, not the grandson. And they allowed him to stop my niece with mother and visiting her own mother.
And what happens in those situations, because the hospital, they're not going to ask for legal proof. You know, somebody comes and say, I'm such and such, they take you for your word. And like Joy was saying, it's a race. Whoever gets there first
Unless you have your documents in order.
and living will.
So the last thing I'll say before we hear from you is that transfer upon death document is important because that transfers the property without a full estate administration.
You save a lot of money. You don't have to
You save
have to open up.
time, you save money, and you transfer the property so that once an individual dies, then they simply take that form to the court and say, make it happen, make this legal, make it reflect what my mom, my sister, my grandmother, or whoever created that document really wanted. Yes, so we'll have to repeat your question so that the live stream individuals can hear us. Yes, they can. Thank you.
Thank you. Certainly, certainly. And we'll be glad to come back anytime. Okay. Yes.
Absolutely. Sure. So one way to transfer your property is in your will. When you have a will, you have to go through the court to administrate
It's called probate, the will.
administration. Yeah.
So if somebody has a will, you just can't go down to the title company and say, oh, here's the will. I'm supposed to have the property. It's a formality. You have to take it down to the court. Here's the will. They have to make sure everything's in order. But if you don't, you can go the route of having a transfer on death deed or affidavit.
Also, when you go through probate court, there are fees associated with that. And there is a filing fee. And then there are other things that you may have to obtain, such as a bond. It depends on the value of the property and a number of things, which is oftentimes a deterrent for people going through probate court.
But if you have a will, in that will, if it says, I want Joy to be my executor, that means her to handle all my business. I can say, I want Joy to be appointed without bond. So that means that nobody has to pay anything.
That is correct. There's still the fees, though, that
Yeah.
you have to pay to go through probate court. But aside from that, you said you didn't have anything and you really didn't want to do a will. You just wanted to make sure your house was passed on to your next of kin. And so for those individuals who sort of buck the system and don't want to do a will, there's what's called a transfer upon death affidavit. That transfer upon death affidavit or deed is a document that you create or that can be created
You can have a lawyer create it, or you can print off a form and fill it out.
that says, when I pass, I want my house transferred to X person, Y person, Z person, or X, Y, and Z person.
And you can designate the percentage. I may want this person to have a 50% share, this person to have 25 and 25.
And you complete that document and you file that document with the court. That then becomes a
Legal document.
legal document. Now, I've had instances where the form was created, but they never turned it in. That's problematic. That's
You gotta
problematic.
file it.
You file that document, and when you pass away, of course, that doesn't trigger anything. It doesn't happen automatically. That person then goes to the court and says, hey, I have a transfer upon death affidavit. Please
Signed.
process it. So that form has to be created, signed, notarized, filed with the court. And then when an individual passes, the person or individual that is to transfer to, they go through the court. In that instance, you do not have to open a full administration. You do that and the property transfers, period. Now, I must be clear. If you have a mortgage on that property, that doesn't go away. The mortgage company still
And it
wants their
follows.
money.
Yeah.
It follows the property. Therefore, if they say it hasn't been paid and we're going to foreclose on it, then that's absolutely legal.
Or the person you're transferring it to is now responsible for that mortgage. So think about their credit. Do they have the credit to do this? Do they have the money to handle it? Because that's another reason we have dilapidated homes and abandoned homes, because grandson, granddaughter, whomever could not afford to pay the mortgage on the home.
I just want to say that in the case of my aunt, she gave me her will. When she died, I took the will to the attorney. He said I can do it.
Mm-hmm.
That is important.
Okay, with a copy. So we had to find the original will. I had no idea where it was. But he found it in the court. She had taken the original and filed it in the court.
Mhm.
So the original was there, but what I had in my possession could not use.
And we
And-
can't admit will copies.
And that is so, so, so important because,
Unless there's an
again,
affidavit. Let me be clear. We can't admit it, but you have to have an affidavit. The attorney who prepared it, witnesses, they have to testify. And if it's found that that is a representation of the original, then technically we'll admit that.
Initially, what he started doing was, my aunt had no children. And so he did her siblings,
Mhm.
so the one left. Then he went to the nieces and nephews in age four.
Mm-hmm.
I happened to come out to number 4. Those other 3 had to say in writing it was okay for me to carry out
Mm-hmm.
what
And so it sounds like your aunt attempted to do everything that she could in her power, but maybe no one knew that the will was already deposited at probate court. And so that's one thing that we have to share. So when you create a will, you need to have the original. I know some of you have already prepared those documents or that document, and you have it in your pocket. We need to be able to find it. We need to know where it is.
Tell us where to find it
And
if
so-
you don't file it at the court.
And the reason why you can deposit it downtown at our probate court is because you know it's safe there. If you keep it at home, that's fine. But what if your house catches on fire? What if you have a flood in your basement like I did? And I just threw away everything. Did you throw away your will? Did you throw away something of value? Yes.
what about if someone has a great project
that you can't get in.
Mhm.
So you will request to do a form to open up that safety deposit box. There is a form that you can do with the probate court to access a safety deposit box, and you take it to the bank. They will acknowledge that, and if you have that form from the court, they will open the safety deposit box.
Don't you
But
have
even
to
before,
open up an estate for that?
it could be a full administration, or depending on what the value of what you think it is, it may not be a full. You may just have to do this form or a release of assets form, and that is still a fee. It's not expensive as a full estate, but there's still a fee. But even before you get to that point, like we were saying, have the conversations, designate who you want, go to the bank with that party, and have that person's name on documentation at the bank to say they have access to open up this safe. Nope. Yes, you do. You have to have everybody's signature together.
In that safety deposit box, I'm sorry, they had their insurance policy in that safety deposit box, or their will. And so if if that policy is supposed to be going toward taking care of funeral
funeral bill.
expenses, and families don't have access to anything, then what's what happens?
And they don't
Yeah.
know to go down to probate court
Yeah.
to get it, because there is a way to get it, but we don't have the knowledge. And I think the purpose, of course, of us being here is to make sure that we spread that knowledge and make sure people know there is a form to get that release to give you authority to open the safety deposit box. You have to pay for it, but there's a form to do it.
And then what it does though is it delays the whole process of the service and that.
And so I'll go back again to the importance of a will for the individuals who don't believe a will is important. People don't think a will is important because they say they don't have anything. But if you have a bank account, that's rule number one, why it's important. Because if you have stuff in a safety deposit box, then nobody can access that if they are not on your account at the bank. And it helps in the administration of everything else. So we talked about the transfer upon death document. But there's also a transfer upon death affidavit for your accounts at the bank. And I think that that is almost as important.
And if I may share, what we've done in our family is gone to the bank together. We didn't do the transfer on death, but my mom put me on all her accounts, and my dad put me on all of their accounts. So right now, it looks as if these accounts belong to both of us. So God forbid, but if something happens in my parents' transition, I don't have to do any paperwork because we're on there jointly on the account. Now I don't get their account statements. I don't want them. They don't get sent to my home. I don't know anything about it. I just said, put me on there. I don't want to look at it. But if something happens, it's like we have a joint account. So then all I have to do is submit the death certificate to the bank, and the account just transfers to me. So we don't even have to worry about listing assets or figuring out who's on what.
And that's the most recommended way of doing it, right? But then we have our families who are not comfortable doing that. I'm not putting him on nothing.
Right.
I'm not fooling with him.
Right.
He ain't taking my money.
And that's our mindset.
And we also know that the younger generation is way more tech savvy than us. And you could be looking at your bank account because it's not going to him or her, but you're like, well, where's my money going? He done got online banking and
He done Zelled it and Cash Apped it.
you're like, what the heck happened? Or we don't necessarily understand how all of those things work. And placing an individual on your account is golden.
If you trust them, we
It's
have that
key.
relationship.
If it's key. But if you say, I don't want to do it that way, then you do that transfer upon death. And here's the thing, we don't think about that. When I opened up my account, my Huntington account, it was because they were giving away something free. They said, if you sign
Get
up
that
for
extra
this account,
$200.
you get blah, blah, blah. Okay, I'll take it. wasn't married at the time. I didn't put anybody on there. And you know what? They didn't ask because they were trying to make a sale. They don't care. They're like, I got another one. Now, what do I get as a sales associate? And I'm like, give me what you're giving me. Give me that free cup. So I got an account with all my money in it. And then when I get married, my husband and I, we create an account. But I got the shoe account over here. This is the one that you get your shoes in, and you get all
we
your
gotta travel.
Amazon.
That's our travel.
And this is the
fund.
one that all your good, all the fun stuff that you don't want to argue about. That's
Everybody might not know about that account.
exactly where you get those shoes from. The
Don't
other
worry
account.
about it.
So I have the other account, and then I pass away. Where does that money go? It does not go to my family. It does not go to my husband because nobody is on that account.
And I'll say in full transparency, my mom her name is also on my account. So just like she put me on all of hers, I have this account since I was in college. She helped me open it. This has been, I jokingly say, our account, since I was 18 years old. Now, this is the account that my paychecks go to, that I pay the bills out of. And my mom knows this, that her name is on the account. So we do it vice versa. God forbid, again, anything happened to me, her name is already on there. It's been on the accounts with checking, saving, whatever's on there. When the bank statement comes, my name and her name are on those accounts.
And we mentioned, I'll just add this, we mentioned the importance of the account information, right? So when our dear Gladys Dunbar was declining, I did all of her paperwork for her. We're all good. We're set, right? And she was at one of the hospice facilities before she went home. We created all these documents. We're good to go. She was an attorney. She knew everything. She put those documents in her bag when she left the facility, and she couldn't find them after that. You can't find them. We just did all of these, and you knew what to do, but and it wasn't that she couldn't find them, is that the other people couldn't find them who were going through her documents and her files. But the one thing that was most important that I can admit we didn't talk about was the code to the bank card.
PIN numbers. You need that PIN number.
Because when her brother came in town and needed to get the money, we didn't have the bank, the password to the. And so what that means is, and the documents that we did was not the transfer upon death affidavit. It was the will, the living will. So she had all of those, but she didn't have the transfer upon death for her bank account. So he needed to get into her bank account before she passed away, and we did not have the numbers.
And I'm going to say one more thing about this, because this is very important, because when you present that death certificate to the bank, they are shutting the account down. They're going to freeze it. So you cannot go to the ATM. You can't go in. You cannot try to make withdrawals, because once they see that, it's done. And I will also tell you all this. I do this as well. Those bank statements, I know we do a lot of electronic banking, but those bank statements that come in the mail, keep them. Every time one comes, shred the other one and keep the latest one, because it has those account numbers on it. It has their name and what accounts they had. Because if you don't have a will and you have to go to probate court and list those assets, you have paper that lists the bank, the name, and the accounts, and you can write those account numbers down. In the funeral home, I've dealt with the funeral home. You can show it to them and say, hey, this is how much that's in the account.
Oh, it just speaks just so well to a case I'm handling with the family now. I have a bunch of relatives in my office, right? And loved ones passed. They know she's got a bank account.
Mm-hmm.
They don't have account number. They don't have a bank statement, but they know the money's there. So, the bank's not going to tell you anything. So you can't go in the bank and say, my loved one's passed and I need to get this money. They're not going to give you access. I found out just very recently, there is a form at probate where, and I haven't actually put it into effect, but shared it with the family, that they can get like a release of information.
And that's exactly what it's called. It won't give you the money, but it will release the bank account information, the name, and the type of accounts, so that you as a funeral home can acknowledge that they have it.
and then share with the family so that they know
Exactly.
that those assets are there and that however, it's going to happen from there. But I was like, uh-oh, what do we do? Because we don't have any proof.
And that release of information is for any accounts. You maybe don't know if it's Chase, PNC, Huntington. List them all. That way, when you get the form from the court that says you have the ability to release the information, not the money, just the information, you take it to those institutions and they'll say, oh, yeah, such and such has an account here. And they give you those statements. So again, you're not releasing money. It's just the information so that you can proceed with burial or whatever you need to take care of your loved one.
So we've talked about the will in some respect. We've talked about the living will, and I want to briefly move over to your healthcare power of attorney and your power of attorney. Yes.
Thank you. I may know this answer. So I have a power of attorney for my cousin who's in a nursing home. Been trying to get it together. Now she's in hospice for the will. I'm going to see her next week. Just remind me, I can have her fill this out. If she's not able to come out to get the affidavit, does she have to be there present with the notary to get it signed? Can you help me out with that? Am I saying that correctly? I want to get her this because we've not had a DNR and it's just back and forth with the hospital. And so, oh, I'm sorry. So
Yeah, you can use this.
With a living will, you can have it witnessed by two individuals. Or if you don't have those two individuals, you can have it notarized. But if she's in a facility, then two individuals can witness it. She does need to be able to communicate or what appears to be in her right mind. And those two individuals probably won't be healthcare professionals. Many facilities refuse to allow their healthcare providers to sign. Many, you can check with the facility because they also have social workers who can work with the families, and those individuals may be able to assist you. But a doctor is very unlikely to sign it.
Because it could be present a conflict of interest. Questions in the
One has to be careful with that too, because I have a friend that had a parent pass, and two individuals had witnessed it, and she couldn't find them. She could not find the individuals who had. One was a person who worked for the bank. One of the bank employees was a witness, and he was nowhere to be found, and the bank would not help with the information that she needed to identify this person.
I'm not sure if another issue had occurred for them to be looking for the people who witnessed it, but there may have been an additional issue. So typically when a document is witnessed, it becomes a valid document. So when you have a will, a power of attorney, a living will, any document that is witnessed is a valid document at that point. So you don't need to find the witnesses unless there is a question as to the validity of that document and the signatures. And that doesn't typically arise, but apparently it can and does in some instances.
I just wanted to point out that neither of the witnesses can be a person appointed as an agent in the document.
No,
Right.
it cannot be an agent. So a situation where I am being appointed as an agent for someone, like say she says, I want Joy to be my agent. I can be appointed as her agent, but I can't also sign the document as a witness. It has to be someone other than the agent.
And same with the will. Your witness cannot also be a beneficiary. If your person in your will is listed as a beneficiary, they cannot be a witness to the will because it presents a conflict.
The clearest example is I go over to Aunt Mary's house and say, "Do you want to write your will?" And she says, "Yeah, I want to leave you everything." Cool. And then she's giving me everything, and then I witnessed it. We need.
Even if there's somebody else, the fact that you, even if there's somebody else, because you have to have two, but the fact that you also witnessed it just presents, doesn't look good.
So, any more questions before we go on and just talk about your power of attorney? The very first thing that I'll say about a power of attorney is that a power of attorney is a document that allows someone to act on your behalf. It allows someone to act on your behalf when you are not able to do so. Their authority never supersedes your authority. So if you are there and able and willing to make a decision, then what you say comes first.
Now, I have a question. I'm going to ask this question for the audience as an audience member. Someone says, well, what's the difference between a healthcare power of attorney and a living will? What do you say?
What I say is that a living will is a document that is specifically designed to express your wishes when you're in a terminally ill state or permanently unconscious. That's a living will, and then we move it to the side. We move the living will to the side, and we talk about the power of attorney. The power of attorney for healthcare strictly relates to healthcare matters. You can have a power of attorney for healthcare, but you can also have a power of attorney for other matters. The healthcare power of attorney relates to healthcare matters only.
And can you have both?
You
You have a
can,
living will and a healthcare power of attorney?
well, we are saying living will and healthcare power of attorney as if they're the same document. And because they are not, absolutely, you can have both of those documents. They are not the same thing. They don't deal with the same issues. Living will becomes invoked when there's a permanently ill, permanently unconscious situation or a terminal illness. Period. That's the end of the living will. If you're never in that state, then you never invoke a living will. When it comes to healthcare matters, it's very important to have a healthcare power of attorney because we all, at some point, deal with healthcare issues. For my family and my parents, they want someone to go to the hospital with them. They want the doctor to be able to talk about situations with that person.
And that's important because of HIPAA. I think everyone knows about HIPAA. So with the healthcare power of attorney, Joy, if I say something's wrong with me, I need to go to the hospital. Joy, I want you to come with me so that you can understand and be able to communicate maybe to our other siblings what's going on. Because, me as mom, I just really can't talk about it. I don't understand these medical terms. I need my baby to come with me and help me understand what's going on. And that's authority for that as well.
And having that person doesn't mean you can't do it. It simply means you have someone to talk about it with. So, with my mom, for example, she has worked in medical billing her whole life. And she wants to talk to me in medical terms. And she's like, oh, yeah, they're doing a PCA. A what? What is that? So she can explain to me some of the things that they say and some of the terminology that they use, but I'm perfectly capable of talking to my own doctors. And that situation can be vice versa. It's not that she doesn't understand, but now I can say, Mom, well, they actually said when you come back, this is going to happen or that is going to happen. So let's talk about what that looks like for our family and how we want to deal with it. So having a healthcare power of attorney allows that doctor to communicate with someone in addition to you. And you want to have that person available. A time when I went to the hospital When they couldn't communicate with me, they wanted to know about a blood transfusion. I wasn't able to say yes or no. So then they looked to my healthcare power of attorney, and that was able to be communicated. And that person said, absolutely, go ahead. I know that's what she wanted. And not only that, I know that's what she needs. So the healthcare power of attorney is when you designate someone to be your agent, someone to act on your behalf, someone for the doctors to talk to when they cannot talk to you. That is where that person comes in at. That is the second form that we have before us today. That form has definitions on it. So page 1 of that document is where you put your name and your date of birth. And then you'll see the definitions that follow for many pages. That includes definition of your living will, which is the first document that we talked about. It tells you again what a permanently unconscious state is. But this is where you name the person that you want your doctor to communicate with. And that is on page 3. You name your agent. It gives you the authority to name not only a first agent, but a second agent, should you desire to do so. That second agent is available when the first agent isn't.
Because they don't answer the phone. So just in case you got somebody listed who does not answer and check voicemail, you got somebody else.
So you indicate on this form who you want to make those decisions, whether it's your son, your daughter. And many times we have spouses that we make all the decisions. I make all the decisions for my wife, or I make all the decisions for my husband. Therefore, if I'm making all the decisions for him, he can't make none for me. I need my oldest son to be able to make that decision. And there may be reasons why your household or your family is set up that way. Therefore, you want your son or your daughter or your sister. My sister and I make all the decisions in our family. And this is who I want to make mine. So it does not have to be your oldest or your second oldest. And I was completing these documents for my uncle, and he has an oldest daughter and then his second daughter. And he and his oldest daughter were not on speaking terms at the time. So he made his youngest daughter the one who would make those decisions. And then the next time we talked, they were speaking. And he said, well, now I want to make my, hey, uncle, you can change it as many times as you want to. But my only request, uncle, is that you be consistent. If you always talk to this daughter, but don't always talk to that daughter, keep that in mind, because we don't know when we'll be in a situation where this needs to be invoked and the doctors need to reach out to someone. And if you guys aren't talking at that time, that could pose a problem. So you decide who you want to name as your agent. You put that name and that contact information in the boxes for your first person and your second person. And this form can be witnessed by 2 individuals who are not named in this form. Those 2 individuals you put there, you allow them to sign, and this document is valid once that is done. If you say, I want to complete this document right now, and I know who I want those individuals to be, then that document can be notarized. Now, notarizing a document occurs when the person who's notarizing sees you sign it. So if you say, I'm going to fill this out later and I'll have it notarized, you can't sign it until you're in front of the person who's going to notarize it. You can't sign it and have it witnessed by 2 individuals unless those individuals witness you signing it.
And again, just to point this out on the form, page 9, or if there are no witnesses. So again, just to reiterate, if there are no witnesses, you have the notary acknowledgement.
We talked about going to the bank. That form for healthcare, the one that we have, this is not the one you would take to a bank. You would need a general power of attorney. You would complete a general power of attorney and list who your agents are, your son, your daughter, your friend, whoever it is. When you complete that document, you actually can take it to the bank and place it on file with your bank.
Just like you can do for the healthcare power, just like you can do with the healthcare power of attorney, placing it on file with your medical institution. It works the same way with the bank. You put it on file with them.
But the important piece about any power of attorney is this: the authority passes away at the time of death. So if you give me the authority to act on your behalf for healthcare matters, I can do that as long as you're in the land of the living. When you pass away, that authority passes away too. And I want to add, the same holds true for a general power of attorney. If I have the power to act on your behalf and I'm handling your financial situations, the authority passes away at the time of death. And many people believe that I have been handling your banking situations for years because you gave me the authority to do so. And you run to the bank and say, hey, mama died. And I want to take all that money out the bank because I can. They will say, no, you can't, because it passes away at the time of death. And that's when the two things we talked about before come into play. Either A, the transfer upon death affidavit at your bank, or the will. If you don't have those two things in place, then you got to march down to probate court.
And go and test
If you didn't put me on your will or have a will created, if you didn't put me on your account as a signer, if you didn't create a transfer upon death situation with the bank, then that now goes through probate court, and that power of attorney no longer matters.
Exactly. Just to reiterate, because I've had situations where I've seen people and they say, well, I have a power of attorney form, but that means nothing once our loved one transitions. Go ahead. You have a question?
Yes, can you have a transfer of death to an organization and not necessarily an individual?
For your bank account information, yeah, you can designate whoever you want your money to go to. It does not have to be an individual. It can be a charity. It can be the church. Whoever, whatever you want it to go to, you can designate that, and that's at your discretion. But again, you're having to do a release of information, all those things that we previously talked about. When you don't have a will, you don't have a person appointed, because that general power of attorney, healthcare power of attorney does not still continue once our person transitions.
I want to add something that is outside of all four of these documents, and that's simply because of a question that was asked about who you can name. So when you have life insurance, that is a contractual agreement between you and your life insurance company. That's not an agreement between anybody else. So if you have a life insurance policy, you name your beneficiaries on your life insurance policy. So when a person has life insurance and they pass away, whatever you have in terms of your funds, they go directly to that individual.
Outside of a will, outside of probate, none of that needs to even come to the court.
It
That is
doesn't
handled
go
outside.
anyplace else. It doesn't go to the funeral home. It doesn't go to pay your mortgage. It doesn't go to take care of your kids. It goes to that individual.
Now, that individual can sign over their right to that money to the funeral home, because we've had a situation where we don't have money to pay for grandma's funeral. So yes, I'm the beneficiary and I am entitled to this money, but I am going to transfer that over to the funeral home. Now, if later we find out grandma had more money in the account and that comes to light, then that goes back to the person to be reimbursed for their money that they signed over as a beneficiary to that account. See two hands. The gentleman in the back had his, and then ma'am, you had yours.
You certainly have informed me and clarified something about something. I thought the power of attorney was the person who kind of managed the that's not so. Well, who is it? And how do you designate it? Who's going to inform an insurance company that the life insurance company that the person pays?
So
Who is it that's going to make sure that everything that happens is supposed to happen?
that person is called your executor that you designate in your will. And that's why we keep saying, you may say you don't have anything, there's nothing to get passed around, I don't have any property or anything. You do, you have things that matter. So if you want to designate a person to take care of your matters after you transition, you're going to appoint them in your will as the named executor. You say, I name such and such to serve as my executor. That person has full authority to handle all of your affairs. They'll get a letter from the court saying that this is the named executor. That person takes that document. If they need to go to the bank, here's my letter, I'm the named executor. If they need to call the insurance company, I am the named executor. I can fax over my form from the court giving me the authority to act on this person's behalf. Because again, those powers of attorneys are null and void once our loved one is gone. So that's why it's so important in the will to have a person designated. Because if you don't, there's no other way to do that.
And when you don't, your great great grandson on the first cousin on the left hand side comes up from Texas
Because he got here first.
and he says, I know they had some money. And he could be doing it with good intentions and goodwill because maybe the rest of the family is unable to do it. And he says, I'm going to step up and I'm going to handle all of this and I'll give y'all everything you need. And he may do that with a good conscience, but he was not the named individual, which will make it much more difficult and many, many hoops for him or her or anyone to jump through because you did not have your say all the way.
Policy, so she was covered for everything she needed. I thought that it was in the state of Ohio that insurance companies and funeral home companies, because of the lobby, they took, the money didn't come to us, she had her beneficiary, so as this changed, the check was sent to me, the funeral home took one check, and they took everything out and sent us the difference. So that's what I've understood for a long time. Are you saying that has changed now?
I am saying that insurance policies have a beneficiary. And as a contractual agreement, the beneficiary is who should be paid. The beneficiary can always sign their rights over to someone else. And so depending on mom's policy,
And it
how
could have been a
much
designation in the policy for something like
and
that.
how much her policy was for, she may have needed all of those to go to pay for what you came up with. I don't know your individual situation and we can't give legal advice, but we can say that the way contracts work is that the money or the beneficiary is who receives the benefit of that contract. And the one thing that I'll also add is if mom had a policy for $10 million, that $10 million goes to her beneficiary. If that's me, at 10 million, all of it goes to me. Now I may decide where I want to send some of it or who I may give it to, but that goes to me.
And again, as a caveat, it could be something in that contract, because we don't know, different insurance companies drafting different way, that could have made provisions for her burial and funeral expenses. Mhm.
Laws of Ohio. Yes. If you have an executive, let's say that's in another state, that person is also governed by Ohio law.
So if you have an out-of-state person named as the executor, they can still serve as the executor, but they have to be bonded. So in the will, it could say, well, I name Joy Kennedy as my executor, and Joy was here in Ohio, but maybe she went to school, started her family out in California. And I said in my will, Joy Kennedy to serve without bond, but because she's out of state, she has to get bonded and she has to an attorney. You have to have an in-state attorney and the person has to get bonded. and not unless it's necessary. You don't have to necessarily fly up here or come up here, but that person has to have an in-state Ohio attorney and be bonded. So bonded is kind of like another word for insurance. Basically, you have to pay what's like a premium annually, and it just ensures that the money you're paying protects the assets in the estate. It's just like insurance. So if something happens, if you're the executor and you run off with the money, you have a bond, and that bond kind of protects the assets so that the family that was entitled to things still has some money there because you're bonded.
So I know that we still need to hear from another entity. Sure.
You want to switch?
Well, once again, thank you. And I just want to, again, can we get a round of applause for our presenters? And they did an awesome, awesome job, brought to light a lot of information, and we had a great conversation. And I also want to acknowledge here our pastor from Antioch, Pastor Napoleon Harris V. Thank you. Thanks for being here. Okay, so I think at this point we want to talk about, and we were kind of assigned to talking about what is advanced planning and what is pre-need, what that term means. And so we can help people understand and what's the advantage of making pre-arrangements. So from here, I'm going to kind of turn over to our expert here, our resident expert at the funeral home. This is Mary Smith, and Mary is a licensed insurance agent, been an agent for many years, and she works with us at the funeral home.
Good morning, everyone. I bought a little capsulized booklet that we give our families because there are actually 133 things that you need to do before you plan a funeral. And I didn't count those. That's in the Ohio Funeral Director's informational, because people think it's simple to just go in, I'll make arrangements, and I can bury my loved one. But I wanted to emphasize some of the things that our attorney said, beginning with the first thing in the booklet, which says full legal name. If your legal name, your date of birth, and your social security number does not match, the computer will kick you out, and that will delay getting that death certificate so you can transact your business. I wanted to emphasize that because sometimes people will use a name all their lives, and it's not a legal name. I use my own family as an example. My father was Sonny, but his real name was Bernard. His brother was Snag. His middle name was James. My Uncle Halbert was Lightning. I mean, everybody had a nickname, and people knew them by the nicknames, but not by their government names. So that government name, social security number, and date of birth has to match. And you'd be surprised as in some families that people don't even know when a person was born. And we want to emphasize that all of this stuff needs to be in place because you don't want anything delayed. Because when someone passes away, you have about 3 or 4 days to make some very expensive, in some cases, and some, definite decisions before you can have a funeral service. One of the things that I I always like to emphasize too is number 4 on the hit parade here says employed by or retired from. Some people think they have insurance in place because they retired from a certain entity, and they find out that when they turned a certain age, maybe that policy went away, or maybe it was reduced by a great amount, as much as 50%, because after a certain age, it might be reduced or it might just disappear altogether. And that's why I like the fact that our attorneys say, you need to know what you need to know before you need to know it. So you want to make sure everything is in place and you have all of the information, and someone in your family needs to know what your wishes are and what your business is. Because I've had situations where I'm working on a pre-arrangement and I said, well, who will handle your affairs once you pass away? Oh, my daughter will know what to do. Have you talked to her? Well, no, but she'll know what to do. Does she know that you are doing this? Well, no, but she'll know what to do. So, and I hear that every day. So, and then you have some people who have all of their affairs in order and nobody knows. Not their children, not their siblings, not their friends. So be sure that you have all of your stuff in order. The other thing is about the insurance. And I want to emphasize this because our attorneys did also. The beneficiary is the person who is named in the contract. The insurance company issues the contract, and they name in that contract who you say is the beneficiary. A mother might have 5 children, and she names all 5 children as the beneficiaries. Well, that one child might say, Mama left me this money. I'm not giving anything to help her be buried. So you got to remember those kinds of things when you name a beneficiary. And also, minor children must have a guardian. You cannot have a child under the age of 18 receive proceeds from a life insurance policy without a guardian. You need to know what the rules of that insurance company are. And I can't emphasize that enough. One of my best examples of how things can really go haywire. A man and wife had been married for several years, and he traveled south to find them some retirement property. Unfortunately or fortunately, he fell in love. He got married. He married a lady down south, had 2 children, had a heart attack and died. His wife, who you can only have one legal wife in America, inherited everything from the insurance company. She was the named beneficiary on his pension, his deferred compensation, his life insurance. And so people were asking, well, what about the other family? She said, what about the other family? They weren't entitled to anything because that's a matter of having your say and having your affairs in order. The other thing I wanted to emphasize is veterans. Veterans have certain entitlements that other people don't. But veterans, we need to remind them that we need a copy of your honorable discharge papers, or DD 214. You might have heard that term in the past. So you want to make sure in this little booklet, it just has just these few little minor things. And if you look at them, those are the ones that usually are the most troublesome because people don't always have all of the information. And one other thing I'd like to say about life insurance, there's no statute of limitations. When you're cleaning out grandma's drawers and closets and so forth, and you run across a policy, maybe it's a $500 benefit, as long as you have a death certificate, you can file that claim because you can only have one claim in life insurance. So I just wanted to emphasize that. And let's move on to personal preferences. We were talking about, we heard a lot of information about funerals, funeral contracts, cemeteries, and so forth. One of the big decisions is, do I want to be buried in a traditional sense, or do I want to be cremated? Don't think that if you have a cremation, you can't be buried. They do have urn sections in cemeteries that are specifically designed with a little baby headstone. That means there's an urn in that ground, or you can go into the mausoleum in the niche, as they call it. And some of them are glass fronts, so you can put all of your life mementos and things that are representative of you in that niche. So that's a big decision. And I've seen, arguments, people say, well, I want to be buried, but then the family decides that they want to have them cremated. So to have your say all the way, you need to decide, and you need to put in writing, or you need to pre-plan ahead of what you want to do. Services to be held at the funeral home or church. That's a big decision too. The funeral home, I know our funeral home across the street, we have the capacity to seat several hundred people for a funeral service. And here at Antioch, you should know the protocol of the church, of what the church provides, if you'll have to come forth with any type of honorariums for the musicians or the minister, or how much in advance you would have to have information with the church. I always suggest that you have all of that stuff in writing so that you know. The favorites that are listed here: scripture, music, color. Color is a big one. Our attorney, Kennedy, has on a beautiful blue dress. One of the worst arguments I heard in the funeral home was, I want mama in a blue dress. I don't want her in blue. I don't like her in blue. You'd be surprised. Mama's glasses on or off. Sometimes mama wears glasses and she looks natural with the glasses. But I don't want her in those glasses when she dies. You need to get all of that information in order and decide it beforehand, because it makes it very, very difficult for the funeral home to work with you. The cemetery, in ground or the mausoleum. Now, I touched briefly on some of the things that are you take into consideration when you're doing in-ground burial or the mausoleum. Please know that cemeteries are just like any other business. Sometimes their rules will allow you to pay for the opening and closing of a grave up front. Some of them require a vault that you have to have in the ground to put the casket in when you're being buried. Some of them don't. For example, Evergreen out on Northfield Road, if you have a metal casket, you don't have to have a vault. And if they've gone through changes there where you could pay the opening and closing up front, just like Lakeview has. But the city will always require that you pay the opening and closing at the time of service. So that's something that you cannot pay for in advance. Did you have something you wanted to say?
I just wanted to, just want to first say that I hope everybody understands what it means to make a pre-arrangement, or what we call advanced planning. And Mary is an advanced planning advisor for us at the funeral home. So it's really important, and I think we've emphasized with the attorneys earlier, you need to have these conversations with your family. We assume that family members know what we want. That's not necessarily the case. It is just, even if you don't go as far as actually sitting with a funeral director or our advanced planning advisor and make an actual pre-arrangement, the conversation needs to be had at the home. Like I believe Joyce said, on a Sunday afternoon or after church or that, but you need to have this conversation. It's a touchy conversation, very sensitive. It brings forward all those issues in the family. Who is the favorite? Who you want to see? who is not around. But if you don't, all this stuff is going to come up after you pass. And unfortunately, all those skeletons that were in the closet, when people pass, usually the emotions, people are going through so much sensitive, emotional stuff, all that stuff rises and comes forward. So it's just so, so important. If you have people in mind, if you want to be buried, if you want to be cremated, don't get this all out on paper, get it in a conversation, and let your family know. If you don't have your say with your family ahead of time, it can result into who's going to get what. People that you've never seen in years, they all of a sudden, they didn't know you, didn't know where you were, hadn't heard from you, and somehow that word gets back. We see this all the time. People that haven't been around for decades, but when that word gets back, they come forward and want to claim this, they want to claim that. They swear that they were told. And if you don't have things in writing in a will, then it's just kind of subject to what is going to be discussed and what's going to be said at that time. And it can arise into arguments. We think people bond together when a loved one passes. Maybe, maybe not. But that's why it's just so important that you at least get the conversation out there. And then maybe after that, take it to the next step. Sit with an advanced planning advisor. Lay all these things out. Set up a contract, where it's like a life insurance where people can either pay into it with one single premium, or you can pay into it and pay over time. But get it done. If there's one thing we all know, at some point we all gonna leave here, right? Nobody gets to stay. We don't wanna face it. I mean, I'm coming to the age, I'm gonna have a birthday coming up soon, and I'm like, well, how did that happen? How did I get here? How did I get this? I thought I had more time. I see people, and as you get older, you see more people around your age who are passing quickly, out of the blue, nothing planned, and bam, it's here. So please, I talked to I talked to both my children. I've got like a file set up for myself. My parents, before they passed, they were in the business forever, and neither one of them had really put it out there. And I had to sit them down. They were up in age. They were still both, coherent and everything. But I had to sit down with them. Now, you figure here, they've been in the business, and they hadn't even faced their own mortality. I had to make them. But, at the end of it, for the time for them, and as they transitioned, it just made us easier for us because we knew what they wanted. And it just made things run so much more smoothly. So, Mary, I'll give it back to you.
Now, one of the things you might want to consider is listing all of your wants. I want to have a funeral service with the in-ground burial. So you want to select a casket. Think about that. Caskets come in so many different forms, be it wood or metal or glass top. Or you could have the George Floyd Promethean bronze for only $37,000. But once you get and I don't mean to make light of it, but you need to think about how much money do I want to spend? The average cost of a funeral is $8,500 without the cemetery. That's not a figure that we throw out. You can get that from the Ohio funeral directors, just getting information. You need to, if you want in-ground burial, you need to select casket, vault if necessary, clothing, flowers, music. All of those things can be outlined in a prearrangement. If you decide to pay for it ahead of time, just like Marcella said, you can do that. If you want to assign an insurance policy, as our attorney said, if the beneficiary is named, you might want to change one of your beneficiaries to a funeral home, and you can do that ahead of time. They have a percentage that goes on the beneficiary form that might represent the amount of the funeral. then if you want to just have the record on file, so that if something does happen, at least you'd have a starting place. But talk to your family. I can't emphasize that enough. Talk to your family. Now, on the back of this little booklet are frequently needed phone numbers by families and contact information. A lot of these places, people do have to contact. They might have to ask a question, might want to ask a question. Some of these people are so helpful. We've mentioned the probate court over and over and over again, and they are very helpful with things. They're paid to serve, and they do serve, and they serve with kindness. What I'd like to do is entertain any questions somebody might have at this point, or some type of feedback that would help, someone here in the room.
There's one thing, can you mention about Medicaid and spend down?
One of the things that we encounter now are the spin down situations, where if you have to go into a nursing homes in the state of Ohio average $7,700 a month. So most people cannot afford those types of numbers, and they are higher at other places. Some as high as $13,000, $14,000 a month, and some as low as $3,500 a month. It varies. But some people have too many assets to qualify for Medicaid, which is a federally funded program administered by the state. And they will pay for your benefits, but they only want you can't have over $2,000 in assets. So some people have thousands of dollars in the bank. Some of them have property that has to be sold. And that could be even, as far as a house or a car or, any other type of properties. And when you have to qualify for Medicaid and have to spend down your assets in order to qualify to have end-of-life care, and it might not even be end-of-life care. Don't think death has an age limit. There are some young people who were maybe injured severely in an accident and might have to be in a nursing home the rest of their lives. They might have to qualify for Medicaid. So they might have to spend down their assets. Anybody have any questions about that? That's usually one of the things that you can do is a prearrangement, a funeral prearrangement, and usually the nursing home recommends it because that's known as an exempted asset. It's for the benefit of the person, but they don't count it against you when they list your asset on a Medicaid application. The other thing is the cash value in your life insurance. Sometimes people will have so much value in their life insurance in the cash value side that it disqualifies them from Medicaid. Whole life insurance, variable annuities, they all have value. Term insurance does not. Term insurance is pure insurance, and it just covers what it covers. It has a death benefit.
So I hope everybody's understanding, like when you go in a nursing home, you've got to release those assets, because after all, if they're paying for your stay, your care in the nursing home, you got to release all those assets to help go toward paying for your whatever happens while you're in the nursing home and the care you receive. So sometimes people, though, that cash, they would tell a family member who's making arrangements for a person in the nursing home to put it into a funeral arrangement. So if the money is set aside, it's set there in a pre-need policy, or that's going to be sitting there until that person passes. And then it can go toward paying for funeral expenses.
And if you are putting cash into a prearrangement, know that it goes into a trust funded. It's in a insurance contract where it's in a trust. So at the time of need, that money is in an outside source and it'll come back to the funeral home. It's not like your funeral home is collecting your money and holding it. Those days are way, way gone. There used to be a time when the funeral home would collect money and hold it for people, but it's to the benefit of everybody, including the funeral home, to have that money in an outside trust. Yes, ma'am. You can do it for somebody else. Say, for example, if you have children, if you have parents, if you have an insurable interest in that person, it can't be your friend from down the street, because that you have to have an insurable interest. Because there are sometimes when people are appointed to do funeral prearrangements by the social worker or so forth, who's helping them at the nursing home. Don't be afraid to ask questions. And if you can't get a good answer from the nursing home, you can go above them. And if somebody says something that you don't understand, please ask questions. Yes, our attorneys were sitting here saying, you know, you're reading this part and it might not make sense to you now, but you might have a question, you know, when you leave. Please ask questions, because you're the one who has to be responsible for that person or for yourself. You want to make sure that you understand everything and that everything is in order, you know, when something happens. And we never know. My youngest pre-need client is 35 years old. He decided what he wanted because his family had a idea of what they were talking about as far as arrangements were concerned. But he bought 6 graves over at Lakeview because he wanted an above ground crypt, and he had to have that much real estate in order to do that. But that was his decision and his money. And he also had a certain casket type that he wanted. And you know, you can decide what you want. Don't think there's any age limitation on, you know, funerals, because people die every day of certain age. And prearrangements, to me, for a younger person, you already have it in place and out of the way, so that if something happens later on in life where you have to go into a nursing facility, you already have that in place.
And I think before you have any other questions, I think we're about to wrap up. Just emphasize that if you have a beneficiary on a policy, they are not obligated to use it for funeral expenses. And I want to be clear about that, because sometimes we feel that that person's going to do the right thing by us, and they don't. There's nothing that says they have to use it.
I think our attorneys emphasize that over and over again. A beneficiary is named. And as I said, my one example, the mama had 5 kids, and you have that one kid who said, Mama left me this money for me. I'm not paying for any part of the funeral. You all have to, and the rest of them have to come up with the rest of the money to pay for the funeral.
Yes, ma'am.
If, like her example, and the kid, the one that has money says, I'm not doing this, and the other 4 don't come up with the cost, then what happens?
The family has to, the family is responsible for the payment of the funeral service, you know, regardless, because the funeral home is just like any other business. You know, they have to pay their people and pay their vendors just like anybody else. But my example was 5 children and 1 child didn't want to pay. And we've had that happen. Or the parent has left the money to the kids, and the kids don't even know that the insurance was for the burial or the funeral service, and they just thought that that was their money. I have a booklet that I give to my families. It's only 4 pages, but it has almost 100 things in it that you have to think about, including clothing. And things thought about is just, it tells you what to do when you have to come to make arrangements. What do you have to bring with you, what the expectations are. And we give that to our families too. But the planning guide is the thing that we give out where you can go through it page by page and list your personal information, your personal preference information. And there's a section on there where you put, you know, the wills and the estate information.
So I guess that about wraps it up. If there are no other questions, again, we just want to thank you. We've been here for a moment, but it seems like time has passed really fast. The incredible information that was shared earlier, I just can't thank our attorneys enough for all that information you shared. And if any of you are interested, I'm sure you can speak with us after the workshop if you need any more information.
Can I say one more thing? When you mentioned about meeting with families on a Sunday afternoon, we have done that. We will come to your meeting. And if you want us to talk about funeral arrangements or pre-arrangements or any other questions that we can answer regarding decisions that have to be made after somebody dies, we have been to family reunions. We've gone to community buildings. Just senior centers, organizational meetings. We've done it all. One last point. I was doing a presentation for a bunch of young women, and one girl got up and ran out of the room. And I was shocked. I said, well, what did I say? But she told me afterwards, she was married and then divorced. She never changed her husband's information on her deferred compensation or her life insurance. And she wanted to make sure that she did it right then because he would get everything if something happened to her. So I always like to emphasize things like that. It does happen. It's real. We'd be happy to answer anything afterwards. So thank you very much.
God bless.